side will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes. Yeah, go ahead. Now, I will caution you all that since this is a case involving a juvenile, that we at the Court of Appeals like to only refer to the children and the participants, even the parents if at all possible, not by their actual names but by initials, or just refer to them as father, mother, etc.
Okay.
Because we are videotaping it and it'll go out, obviously on YouTube, so we don't want to identify anyone.
Okay.
Thank you. Just thought I'd mention it because we all get caught up and sometimes forget.
Yeah, thank you.
May it please the court, I would like to reserve 5 minutes rebuttal time. I represent the appellant, who is the mother in this case. Custody of her son, legal custody was given to maternal aunt, which was her sister, and that's the judgment we are appealing. We would argue for the first argument that she should have been granted a 6-month extension as allowed by statute. She had completed all the objectives of her case plan other than counseling, and it wasn't that she wasn't, she was trying to get into counseling, and as you read in the transcript, even the caseworker said that she was getting the runaround as far as getting counseling scheduled, the mental health counseling. I know that Appellee argued that mother didn't have a job, but that's not one of the requirements in 2151.414 for the best interest of a child. Having employment is not a requirement for being a good parent, basically. She also argues that the father was living with mother, and that he wasn't on the lease so that she could lose her housing. But that was a what if. At the time of the hearing, she had stable housing. They said the house was clean, there was food. So, I mean, you can't base a decision on what ifs, what might happen in the future. You have to look at the current situation. And at that time, she had met all of her objectives other than the counseling which she was trying to get. In addition, temporary custody was given to the aunt on January of 2015. By July, Children's Services had already filed for legal custody to go to the aunt, and in September was the hearing. So it hadn't even been a year before legal custody was granted to the aunt. So she wasn't really given a lot of time to even complete the counseling. And had they granted the 6-month extension, she very well completed the counseling and been reunited with her child. I state in a cite case in there about custody. I mean, that it's a basic and fundamental civil right of a child of a parent from in re married to raise your own child. I feel that she was denied this right because she was so close to getting her child back. If they'd been granted the 6-month extension, it could have come to fruition. We also would argue that the magistrate should have recused himself from hearing the case. Appellant's attorney objected at the beginning of the hearing that because the magistrate had represented the father in a previous case where appellant was the mother.
But not the father of this particular child.
No,
And not her husband who was incarcerated.
that is correct.
And paternity was established eventually, or
Yeah.
no?
Yeah, and for this child, yes,
Yes.
yes.
Okay, thank you.
But he represented the father in another case in which the father got custody against appellant. So obviously, he has knowledge that as a magistrate he might not normally have. And also, I mean, he was advocating for father against mother at that point. So, that can't help but somewhat bias your opinion of appellant at this point. In addition, they allowed the journal entries from that case to be admitted into evidence, which I think further prejudiced the magistrate because it refreshes his memory even more on what happened in the other case where he was against appellant. And the rules of judicial conduct state that a judge shall disqualify himself in any proceedings where the judge's impartiality might reasonably be questioned. And I think that clearly it can reasonably be questioned in this case because of his adversarial position against appellant in a previous case. In addition, I know that the appellee argued that the appellant had waived her right to object because she hadn't done it earlier on in the case. But objection has to be made when the conflict becomes known to be timely. And appellant's attorney testifies that he didn't realize till that day that there was a potential conflict. And he raised the objection that day. And even the magistrate says when appellant's attorney raised the objection, well, what case was that? So later on, for them to argue that they'd already discussed this issue, the magistrate at that point didn't even remember discussing it. And the prosecutor tried to find some journal records stating that the matter had been discussed and they'd waived, that. And she couldn't find any journal entry that stated that. I mean, a court speaks from the record, and there was no record of it. I mean, you can't rely on the memory of the magistrate or the judge or the prosecutor. You have to look at what's in the record, and there wasn't anything that she had raised this objection and had been overruled or she'd waived it prior to that day. So therefore, we argue that she didn't waive her right to object, and that the magistrate should have excused himself. Thank you.
Thank you.
Good morning. May it please the court, I represent Lorain County Children's Services. And in regards to this matter, starting with the first assignment of error, where mother is arguing that she should have been granted a 6-month extension, the evidence does not support that that would have been in the best interest of the child. In fact, the grant of legal custody was in fact supported by competent and credible evidence going to the essential elements of this case. There's not a specific test for the best interest factor, but the court did seek guidance from the statute for permanent custody in regards to just determining what the best interest of a child would be. In addition, the court may also look at whether or not the parents remedied the initial conditions that led the child to be removed from the home, and the court did that in this case as well. Appellant argues that she completed her case plan in entirety except for the mental health counseling portion of the case plan. I think if you read the transcript, you'll see that that's not necessarily the case. There was also some concerns about her ability to provide for basic needs for the child. There was concern that father was residing in the home and that was government subsidized housing, and as such that would put her housing in jeopardy because he was not on the lease at that particular residence. In addition, mother was receiving minimal benefits from the government to help her in regards to meeting basic needs for herself and the child. So I think it's misstated to say that because she didn't have employment, the agency felt that she couldn't have her child reunified with her. I think it's more to the point to say she had no employment or other way that she had shown of providing for herself or her child, and as such, there was a concern about her financial abilities to meet this child's needs. And in addition, the caseworker does admit to the fact that mother had several stumbling blocks and roadblocks in trying to obtain herself mental health counseling. However, part of that from the testimony shows that mother had self-reported that she did not need any mental health counseling. And certainly there was a conflict there then when she tried to obtain mental health counseling, reporting she didn't need any. Certainly the service provider does not necessarily provide counseling when someone is reporting they don't have any mental health concerns. And in addition to that concern, I would say that there was testimony that these mental health concerns for mother were not new, that historically these had been concerns for her, and there had been several years in between the agency bringing to mother's attention that this was a concern in her ability to properly care for her children, and years had passed where she had still not sought herself any mental health treatment to try and address those concerns for the agency. In addition, she did also work with a parent mentor, Mr. Reitman, who testified at the hearing. He also indicated that he did not see any progress with mother, that he had worked with mother in the past with her other children, and in working with her on this child, did not see that there was any difference from mother when he worked with her previously. In addition, he also tried to address some domestic violence concerns, which was also a component of the case plan for mother and father. And he said that that was not, his testimony indicated that he did not feel that they had any insight to why that might be a concern, or how to remedy that, so that that also did not impact their parenting. In addition, there was lots of testimony in regards to the fact that this grant of legal custody would be in the child's best interest. She was with the maternal aunt for a period of at least 9 months, being just, I believe, over a year at the time of the hearing. So this was the only home that the child had ever known. There's also testimony that she was bonded with the other 5 children in the home, that allowed them to keep her home and not have to utilize daycare, that she was thriving in the care of the maternal aunt and her family, and that she was continuing to work with mother and father in order to do visits. And the agency did say that they believed mother could care for the child for a very short period of time during a visitation period, but was more concerned as to whether or not she could do that long-term on a consistent basis to be able to be the primary custodian for the child. There were also some concerns with father being the custodian as he continued to live with mother, and seemed to lack some insight as to why there were concerns with her. And so the GAL did testify she didn't believe that father could adequately make a plan and to keep the child safe and supervised while he had to work. His father was working. In addition, there wasn't any testimony, in fact the opposite, that if mother did complete mental health counseling, that would allow her to reunify in a 6-month period. The argument seemed very much to be more in mother's best interest and not in the child's. So there was testimony that the child would not come to any harm if she remained in the temporary custody of the maternal aunt. However, in looking to a legally secure placement, the agency, the GAL, and other witnesses believed that maternal aunt was likely to provide that in much quicker time than mother would ever be able to provide for the child, or father to that matter. In regards to the possible bias of the magistrate, there is testimony on the record where they talk about whether or not the magistrate had presided over other cases and whether or not that would create a conflict in regards to mother, representing a father on a previous case who was not a party here. So initially, the appellee would argue that there is no conflict, that there's a presumption that a magistrate or a judicial officer is going to follow the law, and he's not going to allow bias in this argument. I think also as well, the testimony is clear that the magistrate initially seems to be unaware that he was ever involved with mother or any of her other children. So I believe that shows that he was not in a position where he was using any previous knowledge that he had about mother or any of her previous cases with children's services and his judgment against her. And
Not just the appearance of impropriety.
the appearance of impropriety.
Yes, whenever when you're in a courtroom and you see that the judge that's hearing your case represented your former spouse or former, whatever it was, the father, one of her other children, and represented that individual in having her child removed or losing custody. Doesn't it seem like, in today's vernacular, it sounds like it's rigged or the fix is in?
I do understand that appearance of impropriety, and I think that would have been stronger if they had come in at the beginning during the adjudication disposition, and at that point had said, this man has previously represented my husband against, or the father of my child against me. However, it seems from the testimony that was a previous conversation that they did have. It's not memorialized in a journal entry, but it does appear to be a conversation that was had on the record at a previous pretrial, and then parents came in at the adjudication and disposition and agreed to those entries.
Is that transcript in front of us?
I don't know that it is.
Okay.
I apologize.
Was there, well, you probably don't know the answer to this as a transcript if you don't know what's in front of us, but, usually in those circumstances, what's done is it's all put on the record, and waiver.
Yes,
Of
and
any
I
potential
I
conflict.
don't believe that there is a formal written waiver in this case.
Well, I'm not even talking necessarily written, I'm talking about a, on the record, Ms. Smith, I represented your blah, blah, blah in prior cases. I understand that you're willing to waive that potential conflict or appearance of impropriety and proceed, is that correct?
And again, I'm not certain if that was done in this case. From the testimony, it sounds like it was just a conversation that was had on the record. I don't know that.
So what are we supposed to do with that then?
I think it's just at this point, if there is even an appearance of impropriety or a conflict, that timeliness in which it was raised, it was an untimely objection at that point. Because there had been a number of pretrials held before this magistrate. There had been agreements to an adjudication and disposition before this magistrate. And in fact, there was half of a contested hearing before this was raised. So at that point, I would say that even if there is a conflict, mother has waived that conflict.
So it's an implicit waiver, not an express waiver.
Yes, I would say that that is the argument at this point, being that it wasn't raised until a further dispositional hearing, and that there had been signed agreements throughout the matter.
And I'm not sure I understand what you mean by signed agreements. I read that, but I'm not sure I understand exactly what you're saying.
I'm saying that during the adjudication and dispositional hearings, the mother and father were provided with proposed agreements to both the adjudication and the disposition, and they were represented by counsel at that time and did sign off on both that adjudication and disposition entry that would have been a magistrate's decision at that time.
Thank you.
Thank you. And with that, I really have nothing further, Your Honors. Thank you.
I would argue, as far as the magistrate, that the counsel says that magistrates didn't initially remember having represented her, but later on in the transcript, he does say, oh yes, I do remember so-and-so was the caseworker. So he clearly did then remember it, and like I said before, in addition, the journal entries were omitted from that case, in this case.
And then what happened when he said that? What did the parties say? I mean, what did the attorney and the mom say at that point?
I honestly don't know.
Okay.
I don't recall.
Because her argument is you can't just sit through the whole thing and then at the end when you lose say, oh, you were biased.
Well, no, I don't think that was the case. The other case plans were agreed upon, so she had nothing to object to. The magistrate was not making a ruling at that time. They were agreeing to these steps, so there was nothing to object to. But then when it came down to the point where the magistrate was going to make a decision, that's when it occurred to her that this may not be fair because he's been on the other side, against me in another case. And I think that at that point is when then her attorney raised the issue, and it was before the hearing started. And really,
Did she recognize him prior to that?
I did not represent her in the lower court, so I don't know the answer to that. But again, there is no record that the issue had been raised before. There should be something, as I said before, in a journal entry or something stating that she waived this, and there was nothing. And the fact that her attorney raised the issue at that hearing would appear that that's when it first became clearer that there could be a conflict, and that's when he raised it. I think that's all. Thank you.
Thank you to both sides. We appreciate your argument to the court. The court will take the matter under advisement and issue a written opinion that will be sent to both sides, as well as we release our opinions on our website, the Supreme Court website. So,
Thank you.
thank you very much again, and I hope you have a good afternoon.